Good evening. I'm your host, Karen Udis, in this series on the network of global corporate control. Today's show is about DC's corrupt business environment and is pre-recorded. DC is going to lose its biggest employer, the World Bank and International Monetary Fund, if it doesn't clean up its corrupt business environment. And that's just for starters. We're also talking about World War III. Thanks to DC TV and Mo Jackson, who's producer and director, and he's also working on audio and teleprompter, and Dolores Harris, who is our floor director. I worked in the World Bank's legal department for 21 years and started reporting world corruption. I am now the acting general counsel of the International Bank for Reconstruction and Development, which is the oldest agency of the World Bank. The 189 ministers of finance and development of the World Bank and IMF have appointed me as the overseer mandate trustee of the global debt facility containing the world's monetary gold reserves. We're now talking about a global currency reset to mint gold currency to end world corruption and replace corrupt paper money. Our series has been on air for a year and a half. We've been talking about one of the world's oldest professions, the legal profession, for many of the segments. I'm going to send the teleprompter for this segment to the District of Columbia Bar in order to develop a continuing legal education course. The legal profession has been serving the network of global corporate control, and this network is also known as the banking cartel. And the objectives of the training session are going to be to acknowledge and respond to the information about the role that the legal profession has played in facilitating the control over the world's legal and monetary systems by the network of global corporate control, which owns 40% of the assets and 60% of the earnings of the companies traded on the world's capital markets. And this network controls the media and issues the world's currencies. People are now aware that the United States Congress has continued to declare a state of emergency since 1861, and that there is a second secret constitution in the United States, and this secret constitution removed a ratified 13th Amendment. This amendment was about titles of nobility and prevented lawyers from serving as officers in the government. People are also aware that the states took away property rights through an act written into the Book of States in 1937. That means that you do not have title to your property, to your cars, to your houses, because the banking cartel has stolen them. The states instead are issuing warranties of title. That's not the same thing. And people are waiving their rights to a hearing in the courts provided for in Article 3 of the Constitution because the bankers are snookering you into hiding contracts that are attached to bank signature cards. And we tried last week to play a 5-minute clip that was recorded in DC TV on June 30th, 2015, but the systems were hacked into, and by the way, this is now the third taping because our systems were hacked into for the other two tapes that we tried to pre-record. I discussed the turnover in the District of Columbia Chief of Police during that clip, and I'm going to try to put that up next week. I'm going to tell you about my letters to and from Mr. Jeffrey Barnett, who is the District of Columbia's Deputy Chief Financial Officer and Treasurer. And my email went to him on the 12th of April, 2011. This was just before or just after I had appeared as a witness in the European Parliament. Dear Mr. Barnett, I would appreciate if you would inform members of the DC government about the unresolved governance issues at the Bretton Woods institutions that we discussed because, as I mentioned, the World Bank will continue to decentralize jobs at headquarters to other countries until the largest shareholder, that's the United States, plays by the rules. The above version of my paper on whistleblower protections in the European Union went to the U.S. Congress and the members of the European Parliament Committee on Budgetary Control. The chronology, that's pages 24 and 34 of the report, did not appear on the committee's website for the public hearing on May 25th, 2011. And then I signed that. And Mr. Barnett responded, and that was on the 20th of May, 2011. To Karen Hudes, subject, Ray, the hearing in the European Union Parliament of May 25th, 2011. Got it, and will pass along to our General Counsel office. Now, that's the end of Mr. Barnett's email to me. I'm continuing to ask the District of Columbia when they're going to end their corrupt business environment. This week, I tweeted about corruption in the District of Columbia, and the attachment to that tweet was what actually got the General Counsel of the D.C. Council, Mr. V. David Svenjak, fired. The teleprompter for the second month that we were on air said, Board of Ethics and Government refused to resume public meeting. They ignored the agenda item on May 7th. Robert Spagnoletti and Deborah Lathan on the 2nd of April complained about Commander Michael Reese, and then Commander Michael Reese was replaced the following week by Melvin Gresham, who was also replaced, and then Miss Lanier was replaced. And we're just going through all the D.C. chiefs of police. There's another comment that you'll be able to read in the teleprompter, which I publish. And I tweeted about Dave Svenjak, the General Counsel of the D.C. Council, on the 9th of May. Quote, I will be sure to let the D.C. government's main employer, the World Bank, know that your office has no stake in providing a favorable business climate by rule of law. And the following week, that was when Mr. Svenjak was replaced by Ellen Efros. What these tweets say is that I am asking Mayor Bowser today whether I can be admitted to the World Bank headquarters buildings or if I have to start bankrupting the new chief of DC's police department with a commercial lien process, and then I'll have to record the lien with Maryland's Secretary of State, and then I'm going to have to try and foreclose on Peter Newsham's house in Montgomery County. This is the steps that I took with Kathy Lanier. The best thing to say at this point is to repeat my previous advice that the District of Columbia is a corrupt business environment and is about to lose its biggest employer. And here's an email of the 2nd of August, which I sent to the D.C. Bar, and the subject was, a very shaky foundation indeed. As you laud, that means congratulate, Gene Shipp, Disciplinary Counsel, and Elizabeth Branda, Executive Attorney, on their pending retirement from the Board on Professional Responsibility for having created a strong foundation, you undermine your own credibility and scatter whatever shards of integrity remained with the legal profession in the District of Columbia. Why on earth did you start out by quoting John F. Kennedy on change is the law of life? The D.C. Bar is perpetuating its corrupt illusion that the United States of America is still governed by the Constitution of 1789 with assistance from Gene Shipp and Elizabeth Banda. This is when we, the people, have not consented to the second secret constitution foisted upon the United States by the network of global corporate control in 1871. State capture is ending, and thanks to your epitaph, so is the legal profession. And then I signed that as acting general counsel of the World Bank and as overseer mandate trustee of the Global Debt Facility. The legal profession's corruption is at the core of the problem. I've been pointing out this corruption for some time, and on the September 13th segment on DCTV this year, I spoke about the corruption in the legal profession. The U.S. Constitution had a 13th Amendment about titles of nobility. This amendment was never repealed. It was simply hidden. The legal profession is going to have to deal with this amendment, which would prevent lawyers from serving in government functions because of their conflicts and divided loyalties. Now, the fact is that I am not covering up these matters. My loyalties are with all the beneficiaries of the Global Debt Facility and also with the Board of Governors of the World Bank and IMF. I'm suggesting that lawyers should review the track record of the power transition model that came to the World Bank in 2004 from the National War College of the U.S. Department of Defense, because it is 90 to 95% accurate in predicting how coalitions will form. The legal profession has not been helping me in ending the corruption and returning the world's wealth to humanity in their currency. It's just the opposite. For reference, here is an email that I sent to the editorial board of the American Bar Association's journal about the global currency reset. And also as background, here's a description of the legal profession's role in money laundering. And there's links in the teleprompter, but let me read something to you. Dear Dan Johnson, when you say that we all want judges that are, quote, respected, independent, nonpartisan, and fair to everyone, close quote, you are unfortunately not speaking on behalf of the legal profession in the United States. The legal profession has been covering up corruption and a constitutional crisis of such magnitude that the United States is facing failure as a nation and risks taking down the rest of the world with it. 3 days after I denounced Justice Scalia, the D.C. Bar, the American Bar Association, the International Law Association, and the rest of the legal profession for hiding the fact that Congress has been extending a state of emergency behind closed doors to justify secret martial law, Justice Scalia met with a mysterious sudden death. Justice Scalia's corpse was hurriedly flown out of Texas in order to avoid a coroner's inquest. The United States is currently in interregnum with no legitimate government. Article 5 is necessary to put the Constitution of 1789 back into effect. My teleprompter was erased from my computer hours before a February 9th broadcast about the Network of Global Corporate Control series in order to delete what Justice Scalia said about Article 5. And this is what Justice Scalia said, quote, the founders inserted this alternative method of obtaining constitutional amendments because they knew the Congress would be unwilling to give attention to many issues the people are concerned with, particularly those involving restrictions on the federal government's own power. The founders foresaw that, and they provided the convention as a remedy. If the only way to get that convention is to take this minimal risk, then it is a reasonable one, close quote. In the live program, DCTV's audio equipment in their studio was hacked. I stated during that transmission how I'm a, quote, sting operation, close quote, revealing corruption in the courts and an interregnum in the legitimate governance of the United States. At minute 3:30, I mentioned how President Obama did not respond to my criticism of his flawed nomination of Merrick Garland. Judge Garland was on a 3-judge panel in my whistleblower retaliation case before the D.C. Circuit Court of Appeals. The oral argument was canceled 3 days before it was scheduled, and the court issued a flawed opinion simply affirming the lower court's opinion when the appellate court was required to consider the matter de novo. That means as if the lower court hadn't decided on it at all. The court ignored the settlement of my case by 188 ministers of finance and development. Judge Garland did not admit that he was not sitting in an Article III court. That's under the Constitution. There are many people interested in whether this country can lead the rest of the world out of this deep corruption, and they are not looking to the legal profession for any help. They noticed how the sound was interrupted during the broadcast just when I described how lawyers were all stonewalling the corruption that I've been reporting, and how the Board of Governors of the World Bank and IMF fired both the General Counsel of the IMF, Sean Hagan, and Christine Lagarde, the IMF's Managing Director, for an illegal attempt to sign away the international monetary gold reserves in the global debt facility. Let's turn to the special role of the District of Columbia and D.C.'s lawyers in this corruption. And this is a letter dated December 9th, 2015, to Washington lawyer, the District of Columbia Bar. Dear Sirs, in Washington Lawyer's December issue, Dolores Dorsonville congratulated Gene Shipp for his 35 years in the District of Columbia Office of Bar Counsel. Gene is absolutely right when he claims that the self-regulation of the legal profession is ours to lose. Gene Shipp's decision to allow the World Bank's legal department to falsify evidence was bad ethics. It's already a foregone conclusion that the world's lawyers have lost their right to self-regulation. America's lawyers went AWOL, that's absent without leave, in covering up the fact that the U.S. is currently under martial law, that people who have paid off mortgages on their land, homes, cars, and other property do not have title because the states are providing mere warranties of title, that federal judges do not preside over the courts under Article III of the U.S. Constitution, but simply administer admiralty law courts. Lawyers even refuse to answer the point-blank question whether Congress has been extending a state of emergency since 1861. We are now wondering whether there should be a legal profession as we put the network of global corporate control, which was identified by Vitali Glotfelder and Battistond of ETH Zurich, into receivership in the global debt facility administered by the Board of Governors of the World Bank and International Monetary Fund. And then I signed the letter as acting general counsel and the legal counsel of the global debt facility. And I forwarded a message on the 9th of December 2015, and the subject was Gene Shipp's 35 years in discipline of the legal profession, and it went to the D.C. Bar. Here is more correspondence that Gene Shipp ignored. The U.S. will continue, thanks to our allies and the Coalition for the Rule of Law on the Board of Governors of the World Bank and IMF, and no thanks to Gene Shipp. And I also sent another email to the D.C. Bar, and that was on the 29th of April 2010, and it was about KPMG's audit of the World Bank's internal controls. Dear Messrs. Shipp, Escata, and Carr, the statement of the World Bank's governors at the conclusion of the spring meetings this past weekend referred to multilateralism and the need to strengthen corporate governance. the World Bank shareholders agreed to a capital increase conditional upon a package to be submitted in 2 months to its shareholders for approval. With global mandates and memberships, the World Bank Group and the IMF must play key roles in a modernized multilateralism. We look forward to board proposals for strengthening corporate governance and accountability at the World Bank Group at the 2010 annual meetings. We urge the boards and World Bank Group management to expedite the necessary procedures so the appropriate resolutions to implement the voice reform and capital packages are submitted to the World Bank and IFC boards of governors by the end of June 2010. Close quote. As you can see from the attached email correspondence with KPMG, the firm that the World Bank hired to conduct an audit of its internal controls, KPMG's Associate General Counsel is trying to prevent me from informing KPMG's audit team about the World Bank's compliance issues. Yesterday, I informed PCAOB, that's the Public Company Accounting Oversight Board, as well as Jules Mouse, who was the World Bank's controller, and Ian Ball, who was the executive director of the International Federation of Accountants, of KPMG's poor audit practices. Yesterday, I also mentioned to Mr. Esketa the stakeholder analysis which predicted 6 years ago that the U.S. would lose the ability to continue to choose the World Bank's president if we did not observe our multilateral obligations under the World Bank's Articles of Agreement. We have now lost the gentleman's agreement, and that's in an attachment. What's currently at stake are many thousands of jobs at the World Bank in the Washington headquarters. I've been assisting the U.S. Congress, GAO, SEC, PCAOB, and Board on Professional Responsibility of the District of Columbia Court of Appeals to fulfill their mandates and bring the World Bank into compliance. And then I signed that. I want to soften what I said about the legal profession a bit based on the death of Antonin Scalia, who may have been ready to disclose the fact that the U.S. is secretly being governed by martial law. Some people are now calling for a commission to investigate whether Justice Scalia was murdered. This is what I said on the 3rd of February about Justice Scalia's refusing to tell the American people that the U.S. is governed by martial law, and that was 10 days before his sudden death. I also mentioned the corruption in the Supreme Court and posted a picture of Justices Antonin Scalia and Clarence Thomas during the DC TV broadcast on the 9th of December on 2015. And on the 10th of February, I told the American Bar Association that lawyers are too corrupt to regulate the legal profession anymore, and that there probably shouldn't be a legal profession. This was after the DC Bar refused to answer my question whether the U.S. was being governed by martial law. And then the following month, I talked about the Constitution of 1789 and the Magna Carta as though the Constitution were in force and effect when this is not the case. King John ceded the UK to the Pope on the 3rd of October, 1213, and he has to pay tribute to the Vatican. We've talked about Article 5 of the Constitution of 1789. Article 5 is the way to measure whether we, the people, have given our consent to the way that we're being governed. When 2/3 of the state legislatures applied to the U.S. Congress for an amendment to the Constitution, there's supposed to be a convention to propose amendments. The state of Wisconsin believed that this threshold was passed in 1929, but the U.S. Congress has refused to do its duty to convene a convention to consider amendments. Instead, Congress has declared a state of emergency behind closed doors. The convention can, as a first order of business, put the Constitution of 1789 back into force. And because the Congress has refused to convene the convention, this means that we are in interregnum. That means we're in the soup, folks. That means that your rights you have no rights. And that's the way we are. We have not consented to being in martial law. And when General Dunford in the alternative media says that he's a white hat and he's actually the existing president, well, you know this is not something that we've consented to. This is something that the banking cartel is just foisting on us. We are now in a situation where, fortunately, because of the declaration and proclamation of the gift of love, that means that we now in the United States have our monetary gold reserves, and we have the institutions that Jose Rizal established for us. We have a way of returning to legality. I want to thank you for listening to another segment of the Network of Global Corporate Control. Today's segment is about DC's corrupt business environment, and that is why we've been talking about DC's lawyers. Until next week, I'm your host, Karen Udis.